on each of the 3 years. I think we've addressed it differently each of these last 3 years. So we're going to start by looking a little bit at privacy. And I think this is probably one of the larger concerns most organizations and most individuals think about. From a legal perspective, and Sarah already told you we're not lawyers, but I read more case law than any non-lawyer probably should, or case decisions. And one of the things we're seeing an awful lot of in the legal field right now is this notion of privacy. In other words, employers can't ask me stuff because it's private, or you can't monitor my stuff as an employee because it's private. Well, there's this thing about privacy on the internet. The internet doesn't forget. And so even if you set your stuff to friends or friends of friends or whatever you set it on whatever social network, most of the case law that I've seen says that because Facebook is designed to help you share with people, because Twitter is designed to help you share with people, because it's posted on the internet, there's an inherent thought that it's not really private in the privacy sense of the word in most use cases in most jurisdictions. And so what that means is that if an organization decides they're going to monitor you, it's difficult to proscribe that. If they decide that they're going to ask you for information, or if I see your information and want to take action on it, it's difficult to prescribe that because the technology doesn't really allow it, the terms of service don't really allow it, and the case law, such that there is to date, doesn't really comport with that either. We've actually seen a couple of cases around personal injury, around sexual harassment, and around workplace disability, where in each instance somebody, the plaintiff or the defendant, has said, my stuff's private, only my friends can see it, therefore it's private. You have 1,800 friends. How is that private? And it's not me asking it, the court is asking that, and of course they have then found it's not really private, and so that raises a significant issue. The other thing associated with privacy is this notion of retention. And one of the challenges that we have with that is that stuff that's publicly available is publicly available. If it's available to your friends, they can see it, they can save it, they can keep it. You don't really have any control over it any more than you have control over an email once it leaves your organization. Once it crosses the firewall, it's fair game. And so as we tweet stuff and post to Facebook and put those pictures up, this can be a challenge. The other increasing problem is that since most of these tools are built with a bias towards sharing, not a bias towards private, you may one day wake up and find out, and I wish I'd brought this picture up here. I have a picture from the ARMA Canada 2010 conference. Last year's conference was at Prince Edward Island, or this past year's, and at the ARMA Canada conference the year before, they took pictures of all of us in our Anne of Green Gables wigs. Those of you who know who that is, she wears pigtails and a kind of a wide-brimmed straw hat, and there's a picture of me floating around looking like that. Messes up my hair something fierce.
Because you actually did that.
I did. Well, I did do that.
Did.
So technically, I did do that. However, I never uploaded the picture, and yet a week later, there it was on my Facebook profile because somebody else tagged me. And increasingly, we're seeing the tools default to allow you to do that. The Facebook facial recognition to make it easier to tag. Well, once it's tagged, it appears, and now your boss is seeing you in Anne of Green Gables, or at the party you were at on Cinco de Mayo this week, or whatever else, and you didn't upload it, but it's still there anyway. And so I think we're going through an interesting evolution with regards to privacy now and over the next couple of years that organizations are going to struggle to come to grips with.